civil redress. The application was vehemently opposed by counsel watching brief for the victim, Mr. Mwangi, who maintained that the ODPP was abusing its powers under Article 157 of the Constitution. According to counsel, there was an elaborate process before a decision to charge is arrived at, and it's not clear why the ODPP was changing tact. Counsel told the court that on the 30th of January 2024, a similar groundless application had been made, which led to the discontinuance of charges against a third accused person, who in fact conspired with the first accused person to commit the offences herein. Counsel informed the court that on the 9th of June 2025, the prosecution had conducted a pre-trial with the witnesses who were in court and ready to proceed with the hearing. Counsel further stated that if a decision to have the charges withdrawn was made on the 14th of May 2025, the investigating officer ought to have communicated this position to the complainant, who had a right to be informed and given reasons for the withdrawal. Counsel maintained the ODPP was abusing the court process and misusing its powers to defeat justice, since the case had 8 witnesses and 2 were in court ready to testify, and he urged the court to reject the application. The court directed the application to be canvassed by way of written submissions, and all parties complied by filing their respective submissions. Allow me not to go through the submissions which are by the party. Let me just go straight to the issues for determination. The court has considered the prosecution application to have the charges withdrawn under Section 7A of the CPC, the objections by counsel for the complainant, and the rival submissions by all the parties. The only issue for determination is whether the prosecution has met the threshold of having the charges herein withdrawn. Section 7A of the CPC provides, in a trial before a subordinate court, a public prosecutor may, with the consent of the court or on instructions of the DPP at any time before judgment is pronounced, withdraw from prosecution of any person, and upon withdrawal, A, if it is made before the accused is called upon to make a defense, he shall be discharged, but the discharge of the accused shall not operate as a bar to subsequent proceedings against him on account of the same facts. Under Article 157 of the Constitution, the DPP is mandated to exercise state powers of prosecution, and in that exercise may discontinue at any stage criminal proceedings against any person. The DPP may, however, not discontinue prosecution without the permission of the court. That is according to Article 158(7) subsection 8 of the Constitution. Under Section 54E of the Office of the Director of Public Prosecution Act No. 2 of 2013, provides that the director shall review a decision to prosecute or not to prosecute any criminal offence. Further, Section 25 of the Act provides for discontinuance of criminal proceedings, while in subsection 2 thereof it provides, pending the permission by the court in accordance to subsection 1, the director may apply orally or in writing to the court for a stay of proceedings with a view that such proceedings may be taken by the director to prevent an abuse of the legal process and protect the public interest. Having considered the position in law, it is clear the ODPP has powers to withdraw under Section 87A of the CPC. This power is, however, subject to the court's approval. I do believe the justification for court's approval is it is the court's business to control the prosecution where the prosecutor acts improperly or not in the interest of justice, or acts beyond his powers vested by the Constitution by carrying out arbitrarily objective under the guise of discharging the function of the office of the prosecutor. In the case of Republic versus Stanley Kihiko, Justice Richard Mongo observed, Section 87A does not give the ODPP powers to do as it pleases, and certainly not for the mere reason that the prosecution is encountering challenges in prosecuting its case. The court must be satisfied there are good grounds for the withdrawal. In the case of George Taitimu versus Chief Magistrate Court Kibera and 2 others, the court stated Section 7A of the CPC gives the learned magistrate broad discretion to accept or reject an application for withdrawal of charges presented by the prosecution. In light of Article 157(11) of the Constitution, which discretion has to be exercised judiciously, taking into account the facts of this case, and in particular, whether the application is made in public interest, in the interest of administration of justice, and to prevent an abuse of the legal process. In Republic versus Leonard Sekento, Justice Nyaguithii observed there are exceptional circumstances on the court's ability to regulate the DPP's jurisdiction. In other words, when he acts improperly, not for the interest of justice, or acts beyond the powers vested by the Constitution, or carrying out an arbitrary objective under the guise of discharging the office of the prosecution. Looking at the above authorities, it is clear that it is blatant that the prosecution is abusing the powers to discontinue proceedings. Permission to withdraw should not be granted. Turning back to the facts before the case, the accused, from the record, the case hearing commenced on the 3rd of June 2021 with 4 accused persons, that is Jayesh Kumar, Gaurav Jayesh Kumar, Midland Howlers, and Super Hakika Limited. The charges were later amended on the 31st of July 2024 after charges against Gaurav Jayesh Kumar and Super Hakika Limited were withdrawn under Section 7A of the CPC. It should be noted that in respect to Gaurav Jayesh Kumar, since he was residing in the UK, the complainant tried to facilitate his extradition from the UK, and as the process was ongoing, the ODPP on the 30th of January 2024 decided to withdraw the charges against Gaurav Jayesh Kumar under Section 7A of the CPC. The reason for the withdrawal being that although Gaurav Jayesh Kumar was a co-director in the company of his father, who is Jayesh Kumar, the first accused person hearing, he did not play any role in respect to the charges before the court. On the 5th of February 2024, the complainant wrote a letter to the ODPP seeking a review of its decision to withdraw the charges against Gaurav Jayesh Kumar, but the court was never notified of the ODPP's position with respect to the said review. Be as it may, the matter was fixed for hearing. Come the 27th of November 2024, the prosecution was ready to proceed for hearing with one witness in court, but the matter was adjourned at the behest of the defense since the counsel in conduct of the matter was out of the country. When the matter came up for hearing on the 17th of March 2024, the prosecution was ready to proceed with two witnesses, but parties agreed, since the court had other prefixed matters and the witnesses' hearing were lengthy, a clear date should be set aside so that the witnesses could be heard, and parties agreed on the 11th of June 2025. Come 11th of June 2025, there were two witnesses in court, and according to the counsel for the victim, the prosecution had in fact conducted a pre-trial with the said witnesses on the 9th of June 2025, but in a surprising twist of events, instead of the prosecution proceeding with the hearing, it made the instant application to have the charges withdrawn under Section 7A of the CPC. The basis of the prosecution's application were instructions received from their head office by a letter dated the 14th of May 2025, indicating the were to petition in the High Court for Insolvency, being petition E012 of 2019 and E008 of 2019, where the issues and investigation were similar to the issues hearing. Having laid out the position in the matter, one thing is apparent. At no time was the complainant ever notified there was an intention of the prosecution to have the charges withdrawn under Section 7A of the CPC on the 11th of June 2025. In fact, I dare say the whole application was shrouded in secrecy since 2 days prior to the hearing on the 9th of June 2025, the prosecution actually conducted a pre-trial with two witnesses and notified them to attend court for the hearing, and indeed on the 11th of June 2025, the two witnesses were in court ready to proceed when the rug was pulled over their feet and the application for withdrawal was made. This begs the question, does the complainant have any rights before a matter is withdrawn in court? In the growing jurisprudence, victims are no longer at the periphery of the justice system, they are no longer spectators. As such, they have rights which, in accordance to Article 50, Subsection 9 of the Constitution of Kenya, are protected and provided for under the Victim Protection Act, VPA. Accordingly, victims play an active role in the criminal justice system and should be involved in the trial process. Under Section 4, Subsection 2B of the VPA, which recognizes the position of the victim, it provides, subject to Subsection 1, the court, administrative authority, or person performing the functions under this act shall ensure that every victim is, as far as possible, given an opportunity to be heard and to respond before any decision making affecting him or her is taken. Under Section 20 of the VPA, it speaks on the right of a victim to submit information and provides a victim has a right to submit any information for consideration to the police, prosecution, on a decision whether or not to lay a charge or to appeal or withdraw. In the case of Republic versus Enoch Wekesa and Michael B. Water, Justice Comey, as she then was, observed, surely, if the case was to be terminated, should the complainant not be given a reason? Should the court that gives the leave to terminate proceedings be a mere rubber stamp? In asking questions that will satisfy the court that there is no abuse of the process and interference of the powers of the DPP, the Constitution provides that for public interest, in the interest of justice, and the legal process should be protected, and this is the duty of the court to ensure. In this case, the complainant had been actively involved in the case and even acquired legal representation in the matter. It's therefore unfathomable that the prosecution to waive the complainant's right to be informed and involved on the decision to withdraw the charges. No effort was made by the prosecution to inform the complainant of their intention to withdraw the charges so that the complainant could exercise its right to avail information for the consideration of the court, yet this is an express provision of the VPA. In the case of Republic versus Peter Kibe and 7 others, the court was keen to note that the Victims Protection Act clearly speaks that if it is the obligation of the state to ensure that the victim is informed of what is going on in their case, the victim stopped being a spectator, a silent partner in their own case, and became an active participant and party, albeit in a constitutional acceptable way. The victim is not challenging the prosecution mandate to prosecute. The victim is simply holding the prosecution and court to account for failing to adhere to the clear provisions of the law. In our constitutional dispensation, the rights of the victim are no less than those of an accused person. The mandate of the ODPP includes the compliance with the law as powers conferred by both statute and the constitution and must be exercised in adherence to the same constitution. Having established that the prosecution breached the express provision of the VPA by failing to inform the complainant of its intention to withdraw the charges, the court will now turn to the reasons advanced by the prosecution for wanting the judge to have the charges withdrawn, which are the existence of two insolvency petitions, being insolvency petition number E012 of 2019 and E008 of 2019, where the prosecution feels the issues in this case can be addressed. It should, however, be noted that by the time these instant charges were preferred in court, the two petitions were already in existence. Before arriving at a decision to charge, the prosecution weighs all the factors, and even if there is a related civil dispute, if a criminal element is established, the charges are still preferred. I believe the reasons why the prosecution instituted the charges is because after investigation, a criminal element had been established against the accused person, the insolvency proceedings notwithstanding. Again, on the 30th of January 2024, when the prosecution decided to have the charges against Gaurav Jayesh Kumar withdrawn, it maintained that the charges against the accused person herein, since there was evidence of the accused person's criminal culpability. The criminal culpability can therefore not be extinguished by the fact that there were insolvency proceedings which were instituted way before these proceedings. Under Section 193A of the CPC provides, notwithstanding the provisions of any other written law, the fact that any matter in issue in any criminal proceedings is also directly or substantially in issue in any pending civil proceeding shall not be a ground for any stay, prohibition, or delay of criminal proceedings. In the case of James Mutisia and others versus Alfaya, Chamwanga, Munalo, and two others, the court held the fact that there exists civil proceedings emanating from the same subject matter is not a bar to institution and continuation of criminal proceedings. Similarly, in the case of Alfred Limitil Lisiba versus Pethard Punk and two others, the court observed the conclusion that one can draw from Section 193A of the CPC is that both civil and criminal jurisdiction can run parallel to each other, and neither can stand in the way of the other unless either of them is being employed to perpetuate ulterior motives or generally to abuse the due process of the court in whatever manner. In the present case, the prosecution has failed to demonstrate that the application for withdrawal has been made for public interest, in the interest of administration of justice, and to prevent an abuse of the legal process. In this case, there is a complainant who maintains having sufficient evidence to establish criminal culpability on the part of the accused, and we also have witnesses who are ready to testify. The court believes the manner in which the application for withdrawal was made, it is in fact the prosecution which is abusing its powers and abusing the court process. In the case of Republic versus Fahim Salid, Justice Muya asked, was the magistrate's court supposed to be a rubber stamp? Or the magistrate ought to interrogate the reasons given by the DPP so as to satisfy himself as to whether they answer the threshold as set in the Constitution, and in particular section Article 157(11) when it comes to withdrawal. In the same vein, having interrogated the reasons advanced by the prosecution, I find the application by the prosecution to have the charges withdrawn under Section 87A is mischievous and not made in the interest of justice. It's for this reason I proceed to decline the application by the prosecution to have the charges withdrawn under Section 87A of the CPC, and I direct the matter to proceed for hearing on merit to allow the court to make a just determination if any criminal culpability has been established on the part of the accused person or not.